Welcome to On the Mark. I'm your host, Mark Rubin. I am so excited to present this podcast series addressing our rapidly changing world and how it is affecting industries and people in unique and interesting ways. As John F. Kennedy once said, change is the law of life, and those who look only to the past or present are certain to miss the future. The business leaders and personalities who I will be interviewing in these podcasts certainly look to the future. And I hope you come away with information and inspiration that helps you adapt in both your business and personal lives. You can find these podcasts on all major platforms, including YouTube, LinkedIn, Facebook, Apple Podcasts, Spotify, and on our website, GoetzPlatzer.com. Welcome to another episode of On the Mark. And today we have one of my law partners, Cliff Katz, who's head of the Bankruptcy and Reorganization Department of the firm. And we're going to be discussing just that, bankruptcy and reorganization, and how things have changed in that world and how people should look at it and when they need it. So Cliff, welcome to On the Mark.
Thank you, Howard. It's a pleasure being here.
So tell us a little about your background, what you do for the firm.
Sure. I'm the head of the bankruptcy and restructuring practice. So anything that comes into the firm dealing with restructuring, collection on a debt that ultimately may have an insolvency component, anything that might have some relative insolvency component will cross my desk. Whether it's a Chapter 11, whether it's Chapter 7, whether it's an asset that ultimately may be subject to a bankruptcy, or a company coming into and wanting to acquire assets from a bankruptcy. So we will handle, and the firm will handle, a broad spectrum of things that ultimately deal with insolvency. It's not just the debtor side, it's not just the creditor side. Certainly can be the landlord side, could be the secured creditor side, the bank, the lender. So if it has an insolvency component, it'll cross my desk.
Okay, so I don't want you to get too technical, but why don't you tell the viewers the short version of the difference between a Chapter 7, a Chapter 11, maybe a Chapter 13.
Okay.
What's the differences between those types of bankruptcy?
So let's talk about the most common bankruptcy that people really see in the news. That's the Chapter 11. Chapter 11 is a restructuring, it's a reorganization, it's a business Chapter 11. And actually, that now takes on a number of different forms within a Chapter 11. There can be a single asset real estate case where you have a company and the sole asset they have is the real property. That's been very, very active, especially in the New York City market, because of the commercial slowdown and COVID and everything else, where people are no longer coming back to the office and have to deal with the issue of empty buildings. That's one. There's called a sub 5 Chapter 11. That's a smaller Chapter 11. It has a debt ceiling of about $3.7 million, and it's meant to be a fast forum where debtors will come in and come out within 90 to 120 days. And of course, you have the regular Chapter 11 that you see some of the larger entities taking advantage of. And that's a restructuring immediately with a debtor in possession. The debtor becomes a debtor in possession. You have all types of different constituents, from a secured creditor, from DIP financing, from a U.S. trustees involvement, etc., and a creditors committees involved. And that type of a restructuring is what initially started all of the other restructurings. The other restructurings were nuances that ultimately, where Congress was sort of defining what is better for those particular type of industries, specifically the real estate industry or the small business type industry. So that's Chapter 11 in a nutshell. The debtor comes in, files a Chapter 11, and most often maintains control of its assets from a consumer perspective and even from a creditor perspective. The creditors or the consumers shouldn't, and usually don't, notice that the company is part of a Chapter 11, despite the fact that they are. A Chapter 7 is sort of the other opposite side of this coin. That's where a company or an individual comes in and basically throws their hands up and says, I no longer want to deal with the stress of all of my creditors. And so they file a Chapter 7 trustee who is a lawyer in the bankruptcy world, who is specializing in this and ultimately assigned by the U.S. Attorney's Office, the Attorney General's office, to administer the estate. What does that mean? Administer the estate? It means that they take a look at what assets are there, they take a look at what liabilities are there, and they try and ultimately collect those assets for the benefit of creditors. And there's a waterfall that is paid. A Chapter 7 is not a reorganization. The business is effectively almost closed immediately on the filing of the Chapter 7, if not closed right after a Chapter 7.
So let me ask you a question. If I have a client that has a business that's failing and he wants to close it up, why can't he just dissolve the corporation? Just go to New York Corporation, file the final tax return, and say the company's being dissolved and walk away. Why would he file a bankruptcy in that
Well,
situation?
the answer to that question is, especially in New York State, if you have a company that owes money, that owes taxes, they may not be able to file a final return to just close it and get rid of everything. Certainly, they may try and close it. Most often, what happens is the owner of that company throws up his hands and says, "We can't get blood from a stone," and just leaves. That leaves things in limbo. That leaves things disorganized, and it leaves the owner potentially subject to certain scrutiny by creditors, by parties in interest, by taxing authorities as to what's going on and why they did that. There is not a fiduciary duty, but there is a business duty to make sure that what you're ultimately doing is in not only the company's best interest, but possibly in your best interest in terms of how you're operating that company. So ultimately, and as a result, by the way, the debtor or the company may try and say, "I'm not ready to give up this business. This is my pride and joy." You see a lot of family businesses that go through this, and they're not ready to say, "I failed in the second generation. I failed in the third generation. Let's do something to make this better. Let's do something. I've tried everything that I can do outside of a chapter, outside of a bankruptcy. I've tried to reduce costs. I've tried to listen to advisors about what to do. I've tried to increase sales. I've done everything that I thought I can do, but I'm still faced with the pressure of lawsuits and people chasing me. And so the bankruptcy is designed for a respite. It's a breathing space so that the business person can focus on the business as opposed to the unknown and multiple areas where he's being pulled in different directions unwittingly.
Well, I find that I don't do that as my main part of the practice. I refer that to you. But I find that a very important component is that a lot of companies have contractual obligations, leases, or other contracts that are just terrible, and it's just putting them out of business because of these contracts.
Mhm.
And I understand that in bankruptcy, they can get out, they can disclaim those contracts and get out of those contracts. Can you tell me when they can and when they can't do that? And
Sure. I'm going to have to get a little technical with you, but ultimately, a contract that is an executory contract in my lingo is a contract that a debtor, after it files, can review and decide it wants to assume or decide it wants to reject. An executory contract essentially is a contract where there is performance that is required on both sides. A typical example, a lease, commercial lease. I give you rent, you give me the space. That's a typical executory contract. And those are contracts that you look at and you say, okay, I think this environment no longer permits us to service this contract in a way that can support my business. And so therefore, I need to get out. Who typically takes advantage of that? Retailers. That's where you see the bulk of the retail bankruptcies in today's market are done effectively to get out of those long-term leases that are either no longer market or for unprofitable stores that can no longer pay the rent that they're supposed to pay. And so you have the ability to start fresh, to reject these leases, to move on without these unprofitable stores and move your sales to other locations to profitable stores. And that's what they're doing.
but it's not just leases. I know leases are the main part of this, but it could be other types of contracts. I could have contracts where they're required to purchase or maybe sell
Yeah.
goods at a price that's just not effective. I mean, we can have situations where I have to sell you my product at a price, and now because of cost and everything else, every time I make a delivery to you, I'm losing money,
Yes.
and I got to get out of that contract.
Yes.
Now, instead of just going out of business, I can disclaim that kind of contract.
Yes, any contract where there is effectively performance on both sides of the line, so to speak, will be deemed executory. There are some caveats. A contract of financial performance with a bank is not an executory contract because they've already given you the money. So all you're doing is repaying them for the money. A personal service contract is not something that you can reject, because if you reject a personal service contract, ultimately you can't then assign it to someone else. You can't force someone.
What is a personal service contract?
Someone's doing something for you. Someone's doing construction personally for you. John Jones ultimately is a salesperson and he's under a contract. I can't, those are the types of things that I can't compel the assumption or rejection, largely because I can't compel that person to work for me or not.
So if a company has an employment contract with somebody,
Mhm.
and the employee is not working out, or the employee is just making too much money, if they file a bankruptcy, can they get under the employment contract, or is that
They
not a
can
contract?
they can reject it, but they wouldn't be able to assume it and or assign it without that person's consent.
But they can reject it
They
and
can.
end the contract.
They can.
So let's talk about who the players are in a bankruptcy.
Sure.
So there's, let's see, I'm sure there's the attorney for the debtor,
As the attorney for the
and
debt.
there's an attorney probably for the creditors,
Mhm.
and there may be secured creditors, and they may have their own attorney.
Correct.
Tell me, who are the players in a traditional bankruptcy?
Sure, and we'll talk in this particular case, we'll talk about a Chapter 11, 'cause
Okay.
that's really the sexy part of it, right? Obviously, there's the debtor, and the debtor has a number of advisors. They have their own attorneys, they may have their own in-house counsel, they have their own special bankruptcy counsel. They will also have insolvency advisors, financial advisors that play a role in this process, and they ultimately may have other type of advisors within their business outside of the reorganization, legal lawyers, for instance, or something like that. Then you then turn to the other side of the equation. Creditors can have lawyers. Uh, this is a unique opportunity because in a Chapter 11 of specific size, the Office of the United States Trustee, which is a arm of the U.S. Attorney's Office, which is an arm of the federal government, has the ability to appoint what's called the Creditors Committee, usually from the top 20 unsecured creditors. And those creditors are there to serve as a fiduciary for the entire estate. That committee has the ability to retain counsel, to retain financial advisors, to retain any type of advisor that they think is necessary and a professional in order to advise it as part of what we should do in a Chapter 11, not from the debtor's perspective, but from the creditor's perspective. In addition, you'll have, if there is a lender, you will have a secured creditor and they will have their own counsel. You may have mezzanine debt that may have their own special counsel. I've had situations where their stockholders have their own special counsel. Every party in interest, every constituency in a bankruptcy, and there are many, as I've just talked about, has the right to their own counsel. And overriding all of this are two arms of the government. One is the Office of the United States Trustee, which I mentioned, and their job is to supervise the bankruptcy to make sure that effectively the debtor, the creditors, and everyone has their role and is playing their role, and that the debtor is complying with its requirements under Chapter 11 and continues to do so, and that the creditors actually also are complying with their requirements or obligations under a Chapter 11 in the committee role. So the U.S. trustees acts as a guidance monitor, someone who ultimately tries to call balls and strikes within that bankruptcy arena. And of course, you have the bankruptcy judge, and he presides over the entire case, makes his own decisions based upon the law and the facts. Hopefully, you agree. Sometimes you don't. And they're in a special court that is outside of the general federal district court. The federal district court has referred jurisdiction to these sites, these bankruptcy sites all around the country. So they're not Article 3 judges, which means they're not appointed for life. They have a certain term, I believe it's 16 years, but they're there, and their role is to facilitate the Chapter 11. It's not to facilitate the debtors, it's not to facilitate the creditors, it's to ultimately facilitate the process of Chapter 11.
So this always I found to be somewhat problematic. Uh, who's paying for all of this? In other words, you have a company that's in trouble.
Right.
That's why it's filing Chapter 11.
Yes.
For whatever reason, they're in trouble. So now there's a lawyer, or not just his own lawyer and his own accountant, but there's a lawyer for the creditors committee,
There is.
and there's usually an accountant for the creditors committee.
There is.
And who's paying for all that?
Well, that's a good question. And it really will depend upon what seat you ultimately are sitting on. Because if I'm wearing my debtor's counsel hat, I will say that the debtor is ultimately paying for this one way or another. Ultimately, generally speaking, as it relates to professionals that are retained by the estate, clearly the
Yeah.
debtor is paying. As it relates to professionals that are retained by the banks or secured creditors, you could argue that the banks are paying for it, and they are to some degree, but in their documents, they have the right to then surcharge the debtor for the costs of their own lawyers, which is something in bankruptcy that happens on occasion, depending upon the amount of the collateral that's there. So,
I thought that was more the norm, that the debtor is paying for all of the professionals for both sides.
well, when you talk about a committee, without question, the committee generally is paid by the debtor's estate. They do a fee app, they're retained pursuant to court order, and the professionals all in the committee are all effectively all seek reimbursement from the debtor. So yes, the debtor is paying for it, assuming there's money. And unfortunately, skilled bankruptcy practitioners have to look at that issue from an attorney's perspective, because you don't, as an attorney, just like everything else, we're in a business and we want to make sure we're there to help, but we're not there to help as a charitable organization. We're there to help to be paid for the services. And so those are things that, as an experienced bankruptcy practitioner, you need to look at to make sure that when you're getting involved in a Chapter 11, whether it's on the debtor side or on the committee side, that there is sufficient assets to cover the expenses that will be incurred. So generally speaking, yes, a committee. As it relates to a secured creditor,
And the lawyer and the accountants.
and
The
any
accountants.
professional,
They're always going to need an accountant, right? You need an
They-
accountant with the lawyer.
especially in some of the mid-sized Chapter 11s that we're involved in, and certainly the larger ones that we're involved in. Absolutely. And the only, I'd say, caveat to that is, if a individual constituent, a creditor, one single creditor, has an individual issue, they want to lift the stay, they want to do this, they want to do that, those types of things are paid by that creditor. So that creditor really needs to take a close look at what it wants, the cost of what it wants, and ultimately, if it gets what it wants, how that plays out in the entirety of the situation. We represent a number of what we'll call equipment lease companies who come in and say, I want my equipment back. The problem ultimately is, at some point, if you don't pay attention as to what you're doing and you get what you asked for, you get the vehicle that did serve as collateral with three wheels and without an engine, and have then spent all of this money to go into a bankruptcy court forum, to fight with the debtor, to fight with the creditors committee, to fight with other constituents, only to be successful and have a piece of collateral that is not worth the fight that you ultimately.
Now, you can when you have a situation where someone's filing bankruptcy and they want to continue to be in business, they have to now get financing to continue in business. So they have to get a new lender. You would think that lenders would be crazy to want to give money to a company that you know is in so much trouble. So I understand that they get some kind of priority position. Can you tell me how companies in bankruptcy manage to get, in some cases, millions and millions of dollars in financing to continue the business, and why those banks would do such a thing?
Well, it can be a very lucrative avenue for institutions that have experience in doing that. What you're really talking about is debtor-in-possession financing. And candidly, most often than not, the debtor-in-possession financing comes from the existing lender. And it does that to protect its own interest, to protect its pre-petition position, such that at the end of the day, you haven't lost the collateral or the asset or the opportunity that you ultimately had pre-petition. Either way, whether it's the existing secured creditor or a new secured creditor, what they get is a lot of different things. Okay, they immediately will get a super priority administrative expense code. What that means is, and this is the bankruptcy code at work. This is the bankruptcy code trying to facilitate people to do business with the debtor. The Chapter 11 really was instituted to facilitate creditors, to push them to at least maybe not encourage, but not discourage them from doing business with a debtor. And how does the bankruptcy code do that? They do that by having a number of things that a bankruptcy judge can order occur. One of them is a super priority administrative expense, so that if you lend me money post petition, you don't just get a claim like everyone else in the bankruptcy. You get the highest claim, you get the first claim. And if there's any money in the first claim, it's yours. You get a super priority lien, you get a first lien. The bankruptcy code has the ability under conditions, or the bankruptcy court has the ability under certain conditions, to order a lien to prime every other lien, such that if there is collateral there and that collateral was prior to the filing, piece of real property, vehicles, receivables, and already have pre-existing liens, you can come in and ask the bankruptcy court to give you, for your new money, a first priority lien on all the stuff that had been previously liened. It's something that is completely unique to the bankruptcy. In a traditional sense, if you have a traditional financing and you're outside of the bankruptcy court, there's no way that a court can enter an order that primes the people that were there ahead of you. But in this situation, that's exactly what the bankruptcy court can do. Doesn't have to do it. There's a criteria for it, talking about harming other people and how it affects the other creditors and what interest does it has and how much money it is and what the money will be done for. And if you can show that the money that they're advancing will be used to generate sufficient funds to satisfy other people in a way that satisfies not only the lender, but other lenders behind them, a bankruptcy court will do that. And so it's a very unique area of the law that, absent this forum, you wouldn't have the advantage.
Now, I remember the way that we met and our firms met is that we did work mostly for debtors, and you
Mhm.
did mostly work for creditors,
Yes.
primarily banks and other financial
Mhm.
institutions, and we would be on other sides of the opposite side of this. So I have a little bit of a flavor on how this works, even though I wasn't doing it myself.
Yes.
And it seems to me that the debtor has the strength, and that they can say to the lender, "You're going to get nothing unless you make a deal with me. So let's make a deal before bankruptcy, because we're in trouble." And
Mhm.
we had situations. I remember I had clients that were doing some things were a little fugazi with
I don't know what
their
about you. I don't want to talk about your
yeah,
Fugazi stuff,
and
especially
remember,
on
we
the
were on the
record.
other side. This was a couple of years ago, and said, "Well, if you're gonna and you were gonna put us out of business, put the client out of business," and we said to your client, "Well, if you're gonna do that, then what's there to collect?" So there's a lot of this negotiation, a lot of the work that you do.
Mhm.
Does it involve really pre-bankruptcy? In other words, the threat that the debtor has of filing a bankruptcy or going out of business is a tool that they
Yeah.
use to prevent to get a lender or to give them a better deal, or to give them something without filing the bankruptcy. Because I don't think it's really, the lender doesn't really want the bankruptcy generally, right?
Well, I guess it depends on what the purpose of the bankruptcy is to do. If the purpose of the bankruptcy is to restructure the debt, the secured debt, in a way that works for the company, then yes, the secured lender wants them to go in. If this, the purpose of the bankruptcy is to ultimately restructure, or maybe not even change the structure of the secured debt, but to affect, for instance, getting rid of leases, it's something that a lender also would encourage, because a bankruptcy is effectively a financial model, right? It's all, the one thing that I really do enjoy about my area of the law is that it should be business practical, from the courts, from the judges, from the lawyers, from every participant. It should be business practical, which means you look at it not from an emotional perspective, but a business practical perspective. What's in the best interest of me as a creditor? What's in the best interests of the debtor? And how do we try and accomplish both of those things, right? More often than not, and I use this expression far too often, probably, but when you're a creditor's lawyer, you're there to negotiate and you're there to do the best job you can. but you're not there to be in a rowboat and shoot a hole in the rowboat and sink us all. That doesn't work, right? So I don't want to be the last seat on the Titanic. I don't want to be the cause that ultimately brings this company to financial ruin, which doesn't help me, clearly doesn't help me. But at the same time, those are the tools that are generally in my toolbox to get the debtor to the table, ultimately to do things that they may not in the first instance want to do.
So let's talk about when there's a filing. There are certain types of debt which is not dischargeable in
Mhm.
bankruptcy. I know by statute, student loans
Yes.
not dischargeable, but
Yes.
for the individual, that's a problem, although that's not something that we deal with too
Correct.
much.
Correct.
But there are other types of situations, like the situation I mentioned before, where there was allegations of fraud.
Yes.
Fraud, fraudulent conduct would not be dischargeable.
Correct.
Uh, Other situations, I'm going to throw a few situations at you, then you can answer.
Okay.
We have a lease situation as a personal guarantee on the lease of the owner of the company. So while the company goes into bankruptcy, it doesn't really help usually the owner, I would think, who
That's true.
personally guaranteed the debt. And what does he do in that kind of situation? So give me your response on how you as a lawyer would handle those type of situations.
Well, you are correct. You are absolutely correct that personal guarantors who don't file don't get the benefit of a discharge. The debtor may get the benefit of a discharge, but the guarantor doesn't. More often than not, the guarantee instrument itself is there to motivate that principal to do the right thing. I mean, more often than not, especially on significant debts, hundreds of millions of dollars of debts, the principal in two lifetimes couldn't repay it. And it's there to motivate them to make sure that what they do potentially is not only in the best interest of the estate, but has the repercussions of whomever holds that guarantee in their hands. And so, a guarantor can always file, and the person who holds the guarantee or the bank that holds the guarantee understands that if you push too hard, what happens is that guarantor files, gets a discharge of that guarantee
On the
obligation.
guarantor files, though, that would probably be a Chapter 7, not a Chapter 11.
It depends upon the individual. You can do a Chapter 11 for an individual if they have real property holdings. You can do a Chapter 13, which is smaller individual restructuring where you keep your house. Chapter 13s are generally there for the probability that you can continue to keep your house. There's a certain amount of debt that is permitted, and there's a certain amount of assets that you keep as a debtor and that you have to disgorge and sell. So it depends on the level of assets you have, and the professional that you have can advise you as to whether you can file a Chapter 7, a 7, or 11, or a 7, or a 13. But those are things, but you're right. And if an individual is filing a 7, then it's game over, right? It's they most likely, as it relates to a guarantee obligation, will get a discharge. So understanding what the purpose of the guarantee is ultimately will enable all the parties to effectively try and negotiate something that works both for the company, the creditor, and the guarantor. Because in a mid-sized Chapter 11, the guarantor is usually the guy that's running the show. And so you want to make sure he's motivated, but you have to provide some incentive for them to do this. They're not going to run a business for the next 10 years solely for the benefit of the mortgage holder or the secured creditor. There has to be a light at the end of the tunnel. And if there's not, then there's no incentive to do those things. So that's really what, the guarantee is about. So, but a guarantee in and of itself is dischargeable by the entity that is obligated to do the guarantee. The things that aren't dischargeable in a bankruptcy, as you had ultimately sort of led to, are things related to fraud, whether that fraud is intentional or that fraud is unintentional, but a consequence of your actions, and whether that fraud results in physical harm. Certainly you can appreciate that um, claims for all kinds of torts are generally not dischargeable. If I come and hit you with a bat and you have serious injury, that type of an injury is not dischargeable.
How about a negligence claim that I hit you with my car by accident?
A negligence claim, provided that there isn't an intentional part of it, is dischargeable. And it's done for that particular reason. That, again, you talk about fault, you talk about injury. Hopefully, if there is a negligence claim, there is insurance. That insurance is not affected by the bankruptcy. So that insurance is deemed to be a third party contract. So if I get hit by a car and the driver has insurance and the driver files, the insurance isn't, my ability to collect from the insurance isn't impacted
Right.
at all by the debt.
So how about a situation where a lender has lent money on we'll call it very creative financial statements by the company that are found to be not accurate. Now, is that automatically considered to be fraudulent, or could the debtor say, "Whoops, I just made an honest error, overvalue the assets by a few $1,000,000," or how is that treated, or what are the
Right.
positions of the parties?
Well, a couple things. One, obviously, there are no fast rules set in stone as to how this ultimately
Right.
plays out. Having said that, if there was creative accounting and there is sufficient evidence as it relates to that creative accounting, there certainly may be grounds to object to the discharge and ultimately get the denial of the discharge. However, that process doesn't happen just because someone said, well, I lent on an invoice and that invoice was made up. Okay, there's a whole litigation that goes along with that, and there's a time period in which that creditor, unwearingly creditor, has to show up and raise his hand and say, "Listen, I was ultimately defrauded by this stack of invoices that never existed," and that has to happen within a certain period of time after the filing, or the unwitting creditor has waived it, not even knowing he could raise it, which is another good reason.
So it's a due diligence requirement for the creditors.
100%. 100%.
They have to look at it and make sure that they followed it up.
They are on the clock.
So let's talk about the process itself. I know in a Chapter 11, ultimately the idea is to file a plan of reorganization. I believe that's what it's called.
Yeah.
How does that go about? How is it? How is that prepared? Who assists in preparing it? Who has to agree? Ultimately, the judge has to approve it. But how does that work?
Well, a plan of reorganization is a technical term, but really all it is a contract between the company and its constituents as to how things are going to ultimately play out after the Chapter 11, after I come out of this Chapter 11. That's really all it is. And it really talks about, and it's set up by a bankruptcy code that creates a foundation of a waterfall. And if you think about a waterfall, there's a top of the waterfall and there's a bottom of the waterfall. And there, as it relates to distributions, secured creditors, administrative creditors, priority creditors are closer to the top of the waterfall. So any plan of reorganization would have to classify them so that they would get paid first, or alternatively, in a way that they agree to.
Well,
So
when you say paid first, does that mean that the secured creditors get 100% before the unsecured creditors get anything?
it could mean that, depending on how things play out. Yes, in a traditional sense, if you're the secured creditor and you object to anyone else getting paid before you, that's called the absolute priority rule. The absolute priority rule in a bankruptcy code says, yes, exactly what you said, that the creditors of higher priority must either do one of two things. They must get paid in full, which also, by the way, may include interest, or agree not to be paid in full in order to let more junior creditors get paid. And the reason that a creditor in a more senior position would do that is largely because they recognize that the opportunity for this debtor to continue benefits them, because they will continue to have an entity that services their loan, that pays back their loan, that maybe takes out new loans, and that does more business that way, and that their collateral is actually equal to or maybe even enhanced by the company by virtue of getting a lot of the excess debt out. And so they look at it by saying, I've improved my collateral position. I'm still going to get payments. As long as I get payments and I'm not in a future default, you want to use some of the money to then satisfy the others so we can get out? let's all get along and do it. And that's the negotiations, that's the leverage between various constituents that always happens in the Chapter 11. It's a very unique and somewhat exciting area because the code was designed so that there are checks and balances for every constituent creditor and the debtor.
Now, in any bank situation or lending situation, usually there's a default interest rate. There's you pay maybe 10% before the
2% a
default.
month.
Yeah, and then afterwards you're spending 2% a month or 24%
Yeah.
per year interest rate. Can a court say, well, let's forget the default interest rate, because that's going to be too onerous, and let's just talk about giving them the interest rate that they originally agreed to? Can they modify a contract like that, or they can't do that without the permission of the lender?
The short answer to that very interesting question, because there is a lot of law on that, is that as I started with this, the bankruptcy court is a court of equity. Okay, what that means is that the bankruptcy judge, more than anybody, looks at the situation from an equitable perspective. What's fair to the debtor? What's fair to the lender? What's fair to the creditors? And we'll look at it and say, listen, um, is your risk in this Chapter 11 equivalent to a 24% interest rate? Or is your risk in this Chapter 11 more equivalent to the contract rate that you ultimately agreed to when you entered into this contract? And those are the types of things that the court will look at: what your collateral base is, how secure you are, how likely, if this thing turns upside down, will you be paid. Really, it really depends upon what your risk is, and what's your risk if things go well, and what's your risk if things don't go well. So the short answer to the question is yes, the bankruptcy court as a court of equity has a lot of power to do a lot of different things in a Chapter 11 that you would never think could happen outside of a Chapter 11. The concept that any court can determined to enforce one provision of a contract and not another is totally unique to the bankruptcy court. So again, the short answer is yes. I don't think they like to do it. I don't think they like to get involved with that. More often than not, courts will defer to the terms of the contract and enforce the terms of the contract. But if it looks at the situation closely, they have the equity to basically say, you're not getting 24, you're getting 8.
Now, I know that we represent a lot of, maybe this term isn't the term that you would use, but I call it hard money lenders. People
Okay.
who give money to debtors who are in somewhat desperate or financial situations, and they get a lot back.
Right.
In terms of interest, maybe they have the right to take over the company and get all the stock of the company. And those terms tend to be pretty onerous because it's a high risk loan, and that's why they're doing it. Do courts tend to, because it's a court of equity, if a contract says that the lender can just take all the stock of the company and just close them down, take everything, goodbye and good luck, and the debtor can say, wait, that's not fair. That's not fair. They're getting more than they should be entitled to, and it's just not fair. In that kind of a situation, are courts more likely to allow a modification of the contract? I know they have the power to. I know that you said that they
Right.
don't like to do it, but when you have a contract that's somewhat onerous, maybe
Sure.
justifiably onerous because of the risk involved,
Right.
are they more likely to change those contracts?
They're not, but ultimately, um, the most predominant thing that's going on there is the concept of the automatic stay, which we hadn't talked about. Okay, when you file a bankruptcy, that is the magic sauce in all of this, which makes this work, the automatic stay. And under, Section 362 of the Bankruptcy Code, the once you file a Chapter 11 or a 7, an order for relief is automatically entered and automatically ordered without any further order of the court. It's an automatic thing, which acts as a huge umbrella from all of the arrows that may be filed and thrown from any of the creditors. And so the things like potentially taking the stock of a company could be stayed if you both file the company and the holding company. And so therefore that asset, the holding company's asset, is the stock. So in your example, the automatic stay would prohibit any mezzanine lender or any lender that has a pledge on the interest of the stock from pursuing that and taking over the company and doing what it wants with the company. Having said that, and there's very significant battles about whether it's appropriate to lift the stay and not lift the stay in a Chapter 11. And there's a lot of different criteria that go into it. Chapter 11 isn't a timeless event. There are certain time frames that ultimately have to occur within a certain period of time. And depending on what type of a debtor you are, will depend on what type of timelines you have. And based on that, the ability to challenge the automatic stay or lift the automatic stay may be easier or harder for creditors. So I would tell you, again, the short answer to the question is courts should be, and they usually are, very reluctant to overwrite the terms of an agreement, a commercial agreement between two people outside or two sophisticated business people outside of a Chapter 11. Having said that, it's not a blank slate. It means that there are some checks and balances, as we talked about, to the rights of the creditor constituency versus the right of the debtor constituency. And so it's a tough fight. It's not a fight that is unwinnable, but ultimately it would be determined by the bankruptcy court as the court of equity. And recognizing that, it lends itself to negotiations among the parties. It lends itself to mediators coming in and solving the problems. And that's always the preferred avenue. To get a consensual resolution among the constituents is always the preferred avenue.
Now, you've been in this business for a long time, and can you tell me what changes that you see in the way courts have interpreted things, or bankruptcies have evolved? I know there was a period of time it was very common to file bankruptcies. There were a lot of small bankruptcies, and then there became a period of time where people were not filing bankruptcies. A lot of bankruptcy lawyers had to start doing other things because there wasn't that much
Right.
particular debtor type work to do. Now that may be changing a little bit more. Uh, Tell me where you see the use of the bankruptcies going in the future, the use of bankruptcy laws, and where we are with that.
Well, bankruptcy as a tool is a very important tool in an entrepreneur's toolbox, period. Full stop. It is a tool, being an entrepreneur, for better or for worse, is a high risk, high reward endeavor. And because of that, you have successes and you have failures. Over the various number of years that I've practiced bankruptcy law, I will tell you that it has become more sophisticated. It has become more accepted in the business community as a tool to facilitate companies' restructuring and assistance. It used to be that lenders wouldn't even think about financing a company in a Chapter 11. It was just too high of a risk. Banks were too conservative. And then all of a sudden, as it became more of a norm, a cottage industry emerged, DIP financing industry, distressed lending environment, distressed lending investing. So all of those things ultimately, I think, enhance the bankruptcy platform. And so, it's not going away. As much as creditors don't like to lose money, and I get it, right? You sold them goods, you thought you were going to get paid 10 cents, and you have your own creditors. I get that. I mean, there's a lot about the bankruptcy code that makes people frustrated and unhappy. But ultimately, the concept that you treat all creditors the same way, that a debtor gets a fresh start, that ultimately lenders can look at this with some degree of confidence that their loan will not be, thrown out, I think makes it a very good tool for business. And I would tell you that when I first started, there was a very discrete amount of people that were the bankruptcy bar. You knew them all, you saw them
I
all.
remember when I started out as a solicitor, I was a lawyer. There was one small firm, and it was a very small firm called Levin and Weintraub.
Sure.
Levin and Weintraub represented all of the big
Sure.
debtors. They were a debtors firm.
Sure.
And when they fell apart, and at that point, bankruptcy was kind of looked down upon by the big
Sure.
firms.
Of course.
Then all the big firms realized, boy, this is really profitable stuff. And they all went to white shoe law firms and became a huge
Correct.
business for a while. And on the debtor side, it became acceptable to be to go into bankruptcy. And now today it's gone through a lot of
Correct. It's funny that you bring up Levin and Weintraub because I knew Levin and Weintraub very well, and it's also funny because I'm not a big sports fan, not a huge football fan, but I am a football fan, and one of my favorite football coaches is Bill Parcells, and everyone in a lot of the ultimate.
I like his girlfriend.
Okay. Okay, but anyway, but ultimately, what other coaches are judged by is not only his standard, but where are they in the coaching tree? Were you a assistant for Bill Parcells? Were you work? Did you work with him? So it falls within the Bill, and that's the same.
That's the same thing.
Levin and
if you worked with Levin and Weintraub, and wherever you went to afterwards, that was the pedigree. That was going to Harvard, was working for Levin and Weintraub.
Correct. That's correct.
Anyway, Cliff, we're at the end. For those of you out there who have businesses or are lenders looking for a bankruptcy lawyer, I mean, Cliff is one of the best. He's my partner, but I've known him for many years before he was my partner, and he does a great job. And you can contact him at Goetz Platzer, and I'm sure he'd be happy to give you advice and give you good advice on whether it's appropriate to file bankruptcy or whether it's appropriate to look at other ways to deal with financial stressful situations. So, Cliff, thank you for being on Mark.
Thank you.
And we look to working together in the future.
It's always my pleasure.
Take care.
I hope you enjoyed this episode of On the Mark. I started this podcast by quoting John F. Kennedy and would like to end it with quoting one of my favorite baseball players, Nolan Ryan. Enjoying success requires the ability to adapt. Only by being open to change will you have a true opportunity to get the most from your talent. I wish you success in staying ahead of the curve instead of behind the 8 ball. Thank you for tuning in.